Hello everyone, Chalen Jackson, Key Account Specialist and Compliance Officer here at Senior Marketing Specialists. I wanted to talk real briefly today about something that you may have seen in the news a lot lately, that you may have been hearing about from other folks in the industry, and that is Chevron Deference, how it came about, how it ended, and why it should matter to you. So in 1984, Chevron sued the Natural Resources Defense Council, and that case went all the way to the Supreme Court and created what we have known as Chevron Deference, or the Chevron Doctrine, that for the last 40 years has granted broad discretion to government agencies, so like CMS, HHS, FCC, FTC, and it basically says that in matters of policy that is based on expert opinion or actual factual data, things like that, in most cases the court should defer to those experts that run that agency rather than kind of arbitrating in many of those cases. So that meant it was really hard to sue a government agency on a matter of policy or regulation and really win, or even really get to the table, so to speak. That is until this year. So about a year ago, I started following a case that you've probably seen in the news recently, Loper Bright Enterprises versus Raimondo and Secretary of Commerce. And as a fanatical angler, you all know this, I love to fish. This was about some herring fishermen that were upset that they were being forced to pay the daily wages of federal inspectors that were on their boats occasionally. So had to inspect the catch, make sure they're using the right equipment, so on and so forth, and they were actually having to pay the wages of those inspectors. So took this all the way to the Supreme Court, and at the end of the day, it became way less about is it legal or not to charge those fees, and it became this big case that really set to overturn Chevron deference. This idea that should a regulatory agency be held to account for the regulations they're creating, or should we just defer to them as experts? And as you've probably heard, the herring fishermen won the case. Chevron deference is dead, so to speak, and regulatory agencies have been put on notice. With the end of deference, we've got two main paths that things can take. Congress is going to have to be a lot more specific in the legislation that they pass, being more specific about how things should be implemented, or these regulatory agencies are going to have to be willing to back their play by showing their work, providing more data, justification for these regulations, not only justification for what they're trying to regulate, but justification in how they came about that as the best possible practice. It's going to create more accountability for bureaucratic overreach for this regulatory process, and it's going to require these agencies to be willing to defend those regulations that they put forth in court. So for us, for agents, for insurance folks, and business folks everywhere, this is a great deal. It means that we have more ability than ever before to challenge unfair and overburdensome regulations in the courts and have a much better chance of winning those arguments as well. So as you may have already seen, we've seen that come through in the July 3rd stay regarding the case about the CMS final rule. We can expect to see that more and more as we go through the coming years for various regulatory agencies such as the FCC, the FTC, HHS, CMS, all of the three-letter agencies that we know and love. So keep an eye on this. Keep an eye on Chevron deference as you hear more and more cases being argued about some of the regulations we face every year. Know that there are people out there fighting for you, are people out there that are trying to hold accountable these regulatory agencies to only put forth regulations that make sense. So with that, I'll end this video. Reach out to the team at Senior Marketing Specialists if you have any more questions or want to learn more about how this can impact your business and what you should do to prepare for this AEP.